How much is the amount granted?
Lord, rupees 6,000 each to the mother and the son, my lord.
That's 12,000.
12,000, my lord.
What is the income of the husband?
Lord, the income of the husband is stated to be 60,000 rupees.
According to him,
Lord, according to him also 60,000.
then why can't he pay 12?
Lord, the dispute is with regard to the relationship itself.
Was it decided by the court?
That issue was not gone into, my lord. May I just draw my lord's kind attention to page number 25.
Relationship with whom? With the wife or
The
paternity
relationship
of
with
the
the
child?
respondents, my lord.
Both the respondents.
Both the respondents. Admittedly, my lord, the petitioner herein is married to some other person in the year 1995 itself. That issue has been answered by the trial court in the affirmative. Therefore, my lord, few important points, my lord. Page number 25.
Let's read.
The petitioners have contended that petitioner number 1 is the wife and petitioner number 2 is the son of the respondent. According to the petitioners, the marriage of the petitioner number 1 with the respondent was performed according to Hindu customs and usage on 8/3/2005 at Sri Goravanahalli Lakshmi Temple, Koratagere Taluk, and said marriage was a love marriage and was performed in presence of Srimati Kempamma and Lakshmamma. Therefore, according to the respondent number 1, this marriage took place in the year 2005. Now, my lord may kindly turn to page number 29, para number 11.
This is filed with the petitioner they are referring to is the wife.
Yes,
Petitioner has contended that the wife and accordingly the marriage has
married in
taken
the year
place.
2005. Now, kindly see page number 29, my lord.
We'll continue reading it so that we'll understand.
Yes, ma'am. Yes. It is also contended that at the time of marriage, the brother-in-law of the first petitioner, by name Kempanna, had given a cash of rupees 25,000 to the respondent and had given golden ornaments to the petitioner number 1. This contention of the petitioners is also totally denied by the respondent. On the other hand, respondent has denied the relationship with the petitioners and contended that petitioners are strangers to him. Petitioner number 1 examined herself as PW1 by way of filing affidavit, has reiterated the petition averment.
Come to para 11.
Para 11. In this background, I have gone through the documentary evidence adduced by the parties, which may help the court to ascertain the relationship between the parties. Exhibit R1 to 4, 6 to 30, 15 to 17 shows that respondent had married one Bhagyamma on 1/6/1995 itself. Above document shows that respondent and said Srimati Bhagyamma are the legally wedded husband and wife. Said documents also shows that respondent through Bhagyamma had two sons, Harish N, who was born on 5/6/1996, and Praveen Kumar N, who was born on 25/5/1999. Therefore, even if the version in the petition that petitioner number 1 had married the respondent on 8/3/2005 is accepted, said marriage during the subsistence of marriage of the respondent with Bhagyamma is not a valid marriage, and petitioner number 1 cannot be held to be legally wedded wife of the respondent.
What is the judgment of the apex court which they are referring to?
My lord, as per the judgment of the apex court, my lord, the proof of marriage cannot be gone into in a maintenance petition. That is the gist, my lord. But however, according to the statement of the respondent number 1 here herself, that she is not the legally wedded wife, my lord, maintenance could not have been awarded. Further, my lord, kindly see page number 37.
In case of respondent, she is not a legally wedded wife.
Yes, my lord. According to her, during the subsistence of the first marriage,
She said it's not like that.
she says that she is aware of the first marriage.
Where did she say?
She says, my lord.
Where is it recorded?
Yes, my lord. I'll just point. Kindly see page number 37, my lord.
37.
37.
Yes.
Para number 17. In the background of above principles, I have gone through the oral and documentary evidence adduced by the parties. PW1 in her evidence admits thus, Baswana Gudi Palyada Gangu Hanumaya Embuvaru Nanna Ganda Ennuvudu Sari.
That's again in English it is written.
Yes, my lord. And page number 38, my lord. Second line. However, while admitting the said aspect of PW1 has clarified that respondent was knowing well that she was married that Ganga Hanumaya, and after death of said Ganga Hanumaya, respondent has married her. Further, PW1 has admitted that ಆ ದಿವಸ ಯಾವುದೇ ಶಾಸ್ತ್ರ ಆಚರಣೆಗಳು ಮದುವೆ ಕಾಲಕ್ಕೆ ನಡೆದಿರಲಿಲ್ಲ. ಆ ದಿವಸ ಎದುರುದಾರರು ಕೇವಲ ತಾಳಿಯನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. Therefore, during the subsistence and further, my lord, At page number 44, kindly see para number
No, no,
24.
39, page number 39, above para 18.
Yes, madam.
Therefore, oral evidence adduced by the petitioner is not sufficient to hold that there was a valid marriage and
Yes.
respondent, which is so and so,
Yes,
has to see whether there is any other documentary evidence which supports the contention of the petitioner.
yes.
Next 18, para 18. is
Para
there.
18. So far as oral evidence of respondent is concerned, respondent who has examined as RW1 has totally denied the allegations of the petitioners about the marriage. So far as evidence of RW2 and 3 is concerned, they say that respondent was married to one Bhagyamma and they have not seen the petitioners and they have no relationship with the respondent. RW2 having said that he has not seen the petitioners, in the cross-examination states that caste of petitioner number 1. Therefore, version of RW2 that he has not seen the petitioners proved to be false. In fact, at page number 44, para number 24, my lord, an application was also made seeking DNA test. The trial court has not undertaken the same, my lord. And at page number 50, para number 31.
He has filed the Aadhaar cards and other things
Yes,
where the husband, this person is shown as the husband.
this person's name is shown. But however, my lord, the subsistence of the earlier marriage is clearly admitted. Bhagyam, and further, my lord, may I just point out one document from the earlier petitions, my lord. Earlier, at first instance, my lord, she had filed a petition, similar petition, against the petitioner herein. And she had withdrawn the said petition, my lord, saying that she does not want to prosecute.
Which year is this? This petition is filed in there 2005.
Yes, my lord. She had filed a memo and withdrawn. And this is again the second petition, playing mischief upon the petitioner, my lord.
Definitely, it is not as simple as your client is putting forth there.
My lord, clearly, my lord, the statements made by her and her conduct of earlier filing a petition, withdrawing, clearly shows that. And further, my lord, the marriage.
20th, para number 20, exhibit P1 is the Aadhaar card of petitioner number 1.
Yes, para 20.
School admission register.
Exhibit P1 is the Aadhaar card of the petitioner number 1, in which the name of husband is shown as Narsimurthy. Exhibit P2 is the Aadhaar card, and Exhibit P3 is the school admission register extract of petitioner number 2, which shows that name of father of petitioner number 2 is Narsimurthy. Further,
The age of the boy.
Lord, age of the boy is shown to be 13 years, my lord. 13 years. My lord, once
So
the,
he must have been joined in the school. There must have been some records pertaining to him.
my lord, her statement that she is married to one Ganga Hanumaya falsifies the
Please, you
document.
have to be very clear.
Yes.
Two things. One is that you have no relationship with her, or she is not your legally wedded wife. As such, she is not entitled for maintenance under 125. So once it's your case that she is not a legally wedded wife, but your client had a relation with her and he is your son, it is
My lord, I am not saying that she is not the legally wedded wife. The trial court has come to the conclusion that,
no, you say that you never knew her.
yes, my lord, she is a stranger. According to the petitioner, she is a stranger, my lord. And she herself goes to say that she is married to one Ganga Hanumaya.
She says after that you married her.
Yes, my lord. But, my lord, the trial court having come to the conclusion that relationship is not proved, was required to direct her to go and get a declaration that she is the wife, my lord. Having not taken that exercise, having not considered the application for DNA test, my lord, fastening the liability.
Your application for that.
I'm sorry, my lord.
Where was your application for
My lord,
that?
during the pendency of the case.
Was it recorded by the court?
Yes, my lord. Para number 24. Page number 44, my lord.
Page, para number?
Page number 44, para number 24.
Please,
In the present case, petitioners had filed application to direct the respondent to undergo DNA test. This
Please come.
application was opposed by respondent.